I'm Jeffrey Rosen. I am the president and CEO of the National Constitution Center, and I've been here for about a year and a half, since June 2013. Last time we talked, I professed my reverence for my favorite justice, Louis Brandeis. So now is the time for me to invoke him. I think his bust was on my GW desk when we talked last, and he's now come to Philadelphia, and he's right back here on my bookshelf. I guess I can lovingly cradle him again. I brandished him last time, so here he is. You're in Philadelphia, and it's with the greatest respect that I welcome Justice Brandeis to Philly to inspire me every day and to help me ask the question that I ask whenever I have a hard question involving the Constitution and new technology. WWBD, what would Brandeis do? So the best place to find, I think, the most perfect expression of how judges can profitably translate the Constitution in light of new technologies is Brandeis's beautiful dissenting opinion in the Olmsted case, where a majority of the court, in a very wooden and formalistic opinion, upheld warrantless wiretapping on the grounds that the framers only wanted to ban searches that involve physical trespass, and in that case, the cops were able to eavesdrop on the suspected bootlegger's phone conversations without physical trespass because they put taps on the wires underneath the sidewalks leading up to his office and didn't have to break into his office. And in his incredible opinion, Brandeis disagreed, and he says time works many changes in technology and invention, but then he said the framers of the Constitution were unalterably attached to the idea that general searches without individualized suspicions were unconstitutional. He told the story of John Wilkes that I talked about earlier and said that the wiretapping at issue in Olmsted was even more invasive than the general warrants that unveiled Wilkes because they have the potential to invade the privacy of people on both ends of the conversation. And then in this amazing, visionary passage, Brandeis anticipates the age of cyberspace, and he says, ways may someday be developed by which it's possible, without physical trespass into secret desk drawers, to extract papers from the home and introduce them in court. A far smaller invasion, he said, was considered a violation of the common law rights of John Wilkes. We need, Brandeis suggested, to translate the Constitution so it protects as much privacy in the age of the wires as it protected at the time of the framing. So I think Brandeis was a living originalist. Jack Balkin has used that phrase in his new book. I described Brandeis in those terms as well. And I think that Brandeis said you start with the paradigm cases that the framers were concerned about, you articulate the principles that they meant to protect, and then you translate the Constitution so it protects not more or less privacy, but the same amount of privacy in light of this new technology as the framers would have insisted on. And that's why I think that Justice Scalia, who would reject the idea of being a living originalist, is very Brandeisian in many of his opinions. In his great opinions in the Kylo case, where he repudiated heat sensing technology without a warrant, in the Jones GPS case, where he suggested that a warrant was presumptively required for the search of a guy's movements for a month with a GPS device affixed without a valid warrant to the bottom of his car. Justice Scalia is accepting Brandeis's challenge to identify framing principles and apply them to new technologies. I can talk about why Brandeis is so important to me. He's just, I think, the most prescient judicial philosopher of the 20th century. He's the most influential justice about protecting privacy in an age of new technology and also protecting free speech in an age of new technology. He's the greatest critic of the curse of bigness, and he more presciently than anyone else warned of the danger of a too big to fail mentality, which caused the depressions of 1913. He anticipated the crash of 29 and would have anticipated that of 2007. And if that weren't enough, he is the greatest advocate of liberal judicial restraint, or call it bipartisan judicial restraint. This is a judge who generally voted to strike down few laws. He thought that the states were laboratories of democracy and should be given broad discretion to experiment when it came to economic legislation. In that sense, he has much that modern conservatives might find appealing. But he also believed in enforcing rights when they were clearly articulated in the text of the Constitution, and wrote the greatest First Amendment dissents in history, as well as the most important dissents about the Fourth Amendment. And if all that weren't enough, he also became, at the age of 50, the leader of the American Zionist movement, even though he was raised without religious observance, and was more responsible than anyone else for the American recognition of the founding of the State of Israel. So he's a great statesperson and a great justice. I think he's especially relevant now in balancing competing demands when privacy and free speech clash. This is the great constitutional issue of our age. We just have seen on the streets of Paris the agonizing effects of those who are determined to silence journalists through violence, and also the very real tensions between the European conception of privacy as dignity, which generally is sympathetic to bans on blasphemy and hate speech that offends the dignity of religions, and the American free speech tradition, which generally holds that truthful but embarrassing speech must be protected unless it's likely to lead to imminent violence. Brandeis was the articulator, better than anyone else, of that American free speech tradition in the Whitney case, where he said that nothing short of an emergency, when there was no room for deliberation, could justify the suppression of truthful but embarrassing speech. On the other hand, Brandeis was also the most influential articulator in America of a right to privacy based in notions of dignity and the idea that emotional harm caused by the instant camera and the tabloid press could be actionable. I'm reading now a fascinating book by Professor Richards, Neil Richards, who argues that Brandeis changed his mind when it came to privacy, and that although he had, as a young scholar in 1890, been sympathetic to a broad right of emotional injury that he wanted to make actionable in the common law of torts, he came, by the time of his totemic free speech dissents, to see free speech as a more important value than dignity, and to say that when the two clashed, free speech should triumph. I emphatically embrace Brandeis's mature view. I think the American free speech tradition, which Brandeis marinated, is the crown jewel of American constitutional law. I think the Europeans are going down a dangerous road when they try to constitutionalize the right to be forgotten, which is essentially a codification of the Brandeis dignitary right, which would allow people to remove truthful but embarrassing information of themselves from the internet. And I think Brandeis's struggles with the balance, and the balance that he ultimately settled on as a mature justice, can guide and inspire us in these anxious times more reliably than anything else. So that's why I really believe that the question WWBD is a good one when we confront the challenges of free speech in the age of Facebook and Google and Je suis Charlie and ISIS. And I'm glad to have Brandeis near me always. I think Brandeis has been more influential than any other justice in shaping the Supreme Court's modern interpretation of both the First Amendment and Fourth Amendment, but he is more honored in the observance than the breach. It was too bad that Justice Scalia didn't cite Justice Brandeis's Olmstead dissent in his own opinions in the Kylo case, or that Justice Alito didn't cite it in his brilliant concurring opinions in the Jones GPS case, because they were channeling Brandeis straight on. Basically, they were years after Olmstead recognizing Brandeis's insight that technological invasions of privacy, even when they don't involve physical trespass, as Alito recognized, threaten the same amount of injury that the general warrants that the framers feared. And Brandeis's Whitney concurrence was embraced and codified in the Brandenburg opinion, which held that you can only ban speech if there's an imminent risk of serious violence. And that is the cornerstone, the foundation of the American free speech tradition. And again, it was Brandeis and not Holmes, who has also wrote beautiful and important free speech dissents. His metaphor of the marketplace of ideas and the need for people to have access to competing views so that ideas could be tested on the battlefield of truth is a powerful metaphor. But Holmes ultimately was a nihilist and a skeptic. He did not share Brandeis's faith in the ability of speech to persuade and of citizens through deliberation to agree at common ends. And it was also Brandeis and not Holmes who came up with the idea that you needed a serious risk of imminent violence in order to justify the suppression of speech. So I think Brandeis is in fact hugely influential. I think his influence will grow as the court confronts issues involving the intersection of speech and privacy in an age of new technology. I just think it's time for more acknowledgement of his influence. I was delighted to see Justice Kagan give a shout out to Justice Brandeis in her talk at Princeton recently. She occupies Brandeis's seat, and she's occupying it very honorably, and she is giving her great predecessor the respect that he's due.